My name is Barrister Anyanwu Ikenna. I have my Bachelor of Arts in English Language from Abia State University, Uturu. I also have my Master's degree from University of Uyo in the same discipline. Before I dive into law, I have my BLL from University of Uyo and also BL from Nigerian Law School, Abuja. I've been in the lecturing business for many years, and my task this morning is to take you on the course Business Law, BAM214. Before we kick off, I would like to refresh our memory from what we did in the preamble of this course, or the general principle of law, where the students were exposed to the knowledge of what law is, or especially the court systems in Nigeria. Though we are not here to talk about principle of law, but it will be necessary for us to remind ourselves what law is, pay more attention on the court systems in Nigeria. Our aim is to ensure that the students, when we go into business law, they'll be in position to know the appropriate court that has the jurisdiction to entertain matters relating to business transactions, more especially when it comes to banking transactions. Let me quickly remind ourselves that law has been defined as those bodies of rules and regulations set aside to regulate the conduct of people in the society. And in as much as we have always said that it's very, very difficult to define the concept of law, but we have all come to agree that for any political or any society to make a headway, there must be rules and norms which people in that society are expected to keep to. And to that extent, that is why we have come to at least attempt a definition of law. Let us now consider certain classifications of law. Like we have always said, under classifications of law, I will rightly put down the classifications of law to you and also to remind you of what we did. So we have the classifications of law. We have the private law and the public law, criminal law and civil law, substantive and procedural law, case law and statute law. We also have the municipal and international law, and we have what we call the common law and equity. We have discussed all these principles in our last course in General Principle of Law. And for purpose of refreshing our memory, I'll quickly run down a little explanation on these concepts. We say private laws are those laws which the individual person has chosen to regulate his life. For instance, private laws like the will's law, it's an example of private law. It's not compulsory to make a will, but once one has chosen to do so, automatically will's law guides the person. Now, under the public law, we also said public law are those laws that are mandatory. It governs every member of the society. It is that law that is an individual person in the society has no choice. For instance, the 1999 Constitution of Federal Republic of Nigeria is a public law. In this case, that law governs every person in that society. We also have the criminal law and the civil law. The criminal law are those laws that governs crime in the society. And we say that the burden of proof in criminal law is beyond reasonable doubt. We also have the civil law. These are laws that guide wrongs or civil actions in the society. And just like that of the criminal law, the burden of proof in civil law is for the person to prove his matter based on weight of evidence, or what you may call based on preponderance of evidence. Now, I would like to emphasize a little on the criminal and the civil law so as to guide us in business law. You see, in criminal law, we have always established that whenever a crime is committed, it is a crime, it is an offense against the state. And it is the state that normally initiates the action. The state is normally represented by the commissioner of police. And in criminal law too, we say that the burden of proof is normally beyond reasonable doubt. You can see that when you make a comparison of the criminal and the civil law, you will agree with us that in civil matters, it is normally the individual persons. Like most of the topics or most of the things we are going to discuss in business law, these are transactions that concern individual persons. And most of these actions are normally fall within the ambit of civil law. In this case, in civil law, it is believed that an individual person takes the action to the court. And the essence of civil action is for the individual person to, file a suit for damages, file for compensation, maybe monetary compensation as a result of breach of contracts. And that is why it is necessary for us to have a good idea of civil matters. And we say that even in civil matter, that you expected that to prove your matter based on preponderance of evidence. In this case, the person initiating any civil matter must show good cause that he's wrong or he has been injured. I want you also to understand, quite like in criminal matter, where the person is expected, when you are making a criminal suit, the essence is to punish the offender, maybe by way of imprisonment. In civil matter, the litigant is interested in collecting money, that is in suing for damages or for compensation. You can see the difference. And in civil matter too, parties that have gone to court, they also have rights to withdraw the matter on their own. But if it is a criminal matter, the matter cannot be withdrawn because it is an offense against the states. I also want you to understand certain terms, like in civil matter, we'll be hearing us mentioning something like liable. When a plea is taken in civil matter, it is normally asked, are you liable or not? But if it is in a criminal matter, the question will rather be, are you guilty or not? So I want you to note, in business law, most of our discussions we'll be hearing certain words like liable. These are certain register that is synonymous with civil matter. And will also agree with me, in civil matters, the person who brought the action to court is normally called the plaintiff, and the person to whom the action is sued against is normally called the defendant. But if it is in a criminal matter, we don't use such. We normally use the word accused. An accused person stands as the defendant. So in business law, you'll be hearing us talking about the plaintiff and the defendants. And it is liable, it will be believed that we are dwelling under the ambit of a civil matter. Now, I will also quickly take us to substantive and procedural law. You discover that in substantive law, these are laws that can be found in one document. They are substantive in nature because they have been enacted and produced in a particular document. Company like KAMA of 1990, Company and Allied Matters Act of 1990 is a substantive law because this body of laws have been reduced in one document. Now, also what we call procedural law are those laws which we may call adjectival laws. These are rules of courts. And the rules of court, we believe, they are there to guide the administration of justice. That is why they are called adjectival law. And now we have what we call the case law. Another name for case law is what we call judicial precedents. Because in that case, we say the judgment of the superior courts is binding on the inferior courts. When the cases are in pari material, in this case, when law or judgments are being taken by superior courts, these judgments form part of what we call law, and they are regarded as case law. And in this case, it is believed that the inferior courts are expected to follow these judgments. Even when these judgments are made in error, it is not within the ambit of the inferior courts to reverse such judgments. And when this is done, we say the court system in Nigeria is keeping to the tenets of the doctrine of judicial precedent, popularly called the doctrine of stare decisis. Stare decisis. Now, we also look at what we call the statute law. The statute laws are those laws that have been passed through the normal legislative process, and they've been enacted following the normal legislative process of a particular state. And when these laws come into force, they are called statute law. Municipal law and international law. Municipal law are those laws, we call them the local law of the states. For instance, the 1999 Constitution of Federal Republic of Nigeria is a municipal law because that law regulates only individuals in Nigeria. We cannot apply the the sections of 1999 Constitution to any other country. So it is municipal because it relates to Nigeria. You can still call it a local law in that sense. But international law are those laws that apply between nation and nation. Nigeria is a member of United Nations, and by that it must have signed the treaty. So the treaty, the 1945 Convention of United Nations Charter, is also binding in Nigeria because Nigeria is a signatory or a member of United Nations. So international law is that law that governs nation against nation. Now, we have common law and equity. Common law are those laws of Great Britain, received the English laws of Great Britain, and including what we may call the Statute of General Applications that were enforced in Great Britain as of 1900. Like I said, I just want to refresh your memory so that we will not keep lost of the track of what we did in the last course on general principle of law. Then equity. Equity are those rules of courts that have come to mitigate the hardship of common law. They are laws. They are laws. But they are equitable laws. They're equitable in the sense that they have come to ameliorate the hardship of common law. So they work hand in hand. They work hand in hand. Now, these are the classifications of law in Nigeria. And we also want to draw your attention to the court systems, so that by the time we have an idea of the court systems in Nigeria and we go into the courts proper, we'll be in position to know why this court has the jurisdiction to entertain a particular matter. Right, we have the court systems in Nigeria. Our essence of introducing the court systems in Nigeria is to enable you as students to know the particular courts which might have jurisdiction to entertain matters relating to business transactions between persons and persons, company and company. Now, the court systems in Nigeria, we classify them to what we call the superior courts and the inferior courts. Under the superior courts, these are courts of records. When a court is said to be a superior court, that means it is a court whose record can be relied upon. In that case, when a matter or a judgment has been passed on a superior court and the matter goes on appeal, it is now left on the superior courts on appeal can rely on the records of the lower courts. That is why we call it superior courts of records. Now, in Nigeria, we have under the superior courts, we have the Supreme Court, which is the apex court. We have the Court of Appeal. We have the Federal High Court, and we have the State High Court. Part of the Court of Appeal, we also have what we call the Sharia Court of Appeal and the Customary Court of Appeal. These are superior courts. They are called superior courts because their records are relied upon. Down there, we also have the second arm, which we call the inferior courts. And these inferior courts, like the magistrate courts, customary courts, Sharia courts, and so on and so forth. These are inferior courts because they are court of, summary trials. Their records are not relied upon. If any matter goes on appeal from magistrate court to high court, for instance, the high court will not rely on the record of the magistrate court per se, but rather high court will presume that the matter is coming before her for the first time. And in that case, we say the court will look into the matter de novo. De novo in the sense that the matter will be taken afresh. That is why we don't regard these inferior courts as court of records. Because whenever they pass their judgment and their judgment goes on appeal, definitely what the Supreme Court, the High Court will sit on the matter de novo afresh. Now, having said that, you can see the jurisdiction. of the Supreme Court is the highest court of the land. Judgments, whenever judgment is passed in the Supreme Court, that is final. It does not go on appeal. And the Court of Appeal is following the Supreme Court. Matters that come to Court of Appeal comes on appeal, whether from the Federal High Court or from the State High Court. In that case, whenever the judgment is delivered at the Supreme Court, at the Federal High Court, or at the Court of Appeal, the person or the litigant has option to go on appeal or rest his case at that moment. And following is what we call the Federal High Court. The Federal High Courts they're established by the federal governments. We call this under the Federal Court. The same thing with that of Court of Appeal, Supreme Court. These are courts that are established by the federal government. And the Federal High Court has jurisdiction. I want my students to pay attention on this. The Federal High Court has jurisdiction to entertain matters relating to companies, matters relating to banks transactions. It is within the Federal High Court that entertains such issues. When contracts are being entered between a person and a bank, between a person and a company, and so on and so forth, the person has right to bring his action to Federal High Court. The essence is that the Constitution of Federal Republic of Nigeria empowers the Federal High Court to entertain matters relating to this. State High Courts, though there is recently a case where it had been said that the Federal High Court, the State High Court, can as well entertain matters relating to bank relationship with person. That is, in this case, that the matter can go, that the State High Court can entertain the matter. But note that it is only where the issue relates to the customer's rights as regards to the bank, and not where there is a breach of contract between the customer and bank. I want my students to know this, that the State High Courts can entertain a matter relating to the rights of the customer when a customer wants to enforce his rights, which has been breached as a result of the transaction. But a situation where there is a breach arising from the bank against its customer, in this case the matter must be entertained by the Federal High Court. But to be on the safe side, it is always good to bring your matter before the Federal High Court. So that is why Federal High Court is very, very important in this course, for students to understand that where it comes to business law, that most of the business transactions, or most of the business, the conflict disputes arising from breach of business transactions or contracts are normally entertained at the Federal High Court. Now, having said this, the essence is for us to understand the court systems and where this matter lies within the Federal High Court, and the litigant is aggrieved at the judgment of the Federal High Court. He can now take this matter to Court of Appeal. And where the Court of Appeal passes judgment on the same matter and the litigant is not still comfortable with the judgment, he can now proceed to Supreme Court. And when the Supreme Court gives its final judgment on the matter, it is presumed that the case has come to an end. There is no right of appeal in this case. Now, having known this, our interest is not to discuss the inferior courts, because the inferior courts might not have much to do in our course before us. Our interest is to look at the jurisdiction of the Federal High Court. Now, having said that, we proceed proper to what we call law of contract, which is, I believe that the students are having an introductory aspect of this course. What law is, what are the classifications of law, and what is the court systems in Nigeria, having in mind that we are pinning ourselves down to Federal High Court, which might have most jurisdictions entertaining matters relating to business transactions. We are now going into the course proper, and we shall start with what is contracts.